Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Welcome to another episode of Empowering Plans with the FIA Group. I'm Cindy Merrell. I'm an attorney here with the FIA Group, and I do a lot of subrogation every day. And I'm joined today by Andrew Silverio. He is a director over in our PGC department. Hi, Andrew.
Hey, Cindy. How's it going?
Good. Today, we're going to talk about two different models of processing claims whenever there's another primary payor. So today we're going to talk about pend and pay, which is one of the models, and that's when a plan suspends payment of accident-related claims unless and until a PIP or a MedPay ledger is provided by the member to the plan. And the second model we're going to talk about is the pay and chase model. It's when the plan elects to pay the accident-related claims as they come in, and then they later seek reimbursement from any or all other payors that would have been liable. I think that to start this conversation, I think we need to back up to how the plan is able to do this. They're able to do this through their coordination of benefits language. And that's why I asked Andrew to be here today, because Andrew, in our PGC department, we have the world's best plan language. And I want you to tell us more about plan language and the coordination of benefits.
Sure, thanks. So this specific issue with these two payment models of pay and chase versus pend and pay, pend for details, whatever you want to call it, there's a lot of overlap between coordination of benefits and then, third-party liability-based rights like subrogation, reimbursement. Most of what we do in recovery, we sort of call it all subro, but most of it is actually reimbursement. And when it comes down to it, what those reimbursement actions really are is just coordination of benefits that's happening after the fact, where, whether it's a motor vehicle coverage like PIP or MedPay, or a liability coverage, or even a liable third party, the basis is that the plan paid those expenses and that party should have paid them in the first place. So you can look at it as coordination of benefits, where you should have paid this at all, period, or you should have paid this first. We picked it up, and so we need you to pay us back. It's really just, coordination of benefits up front versus coordination of benefits after the fact. So, the difference is really timing, and whichever approach, we'll talk a little bit about the pros and cons of each, but whichever approach a plan wants to take, it's really crucial to have plan language in place to support that, right? Because any adverse benefit determination, which is what the code calls any denial of benefits in whole or in part, has to be supported by plan language. So I'll thump our drum a little bit real quick. Our coordination of benefits language in our FIA templates supports either approach, which gives a plan some flexibility, but it's still important to administer the plan consistently. So whether it's going to be pay and chase, pend and pay, pend for details, whatever you want to call it, it's important to always administer that in the same way, not, pay and chase, except when a really big claim comes in. And then, you're going to deny until you have all the information in place. That's going to be difficult to defend if there's some sort of claim that it's arbitrary or discriminatory or something like that. Cindy, anything to add?
Yeah, so sometimes what I've seen, and this happens pretty regularly, we have situations where the plan says, okay, we got this large claim and we think that there's an auto accident. And what we're sometimes seeing is we haven't had a chance to get any additional information, and they're denying the claim when we don't know yet if there is even another primary payer, if there is another liable payer out there. It's something to consider when reviewing the approach and make sure that you have all the information that you can at the time. And I know we'll get into greater detail about pros and cons, but when you're talking about consistent administration of the plan, just because it's a large claim, it has to be treated the same as you would have treated the smaller claim that came in.
That's right.
I just want to plug that in there.
Yeah, absolutely. Absolutely right. And then also in the situation you were just talking about, it's important to distinguish between two similar but distinct situations where, let's say you have another payer available and known, and the question is, do we pay up front and then go after them, or do we deny until they pay? Versus if you don't know what's out there, you don't have, say, an accident report or an accident questionnaire, and you don't know if there's another payer out there. You don't know if an exclusion might apply. Maybe there's some indication that a motor vehicle accident resulted from like an illegal act or something like that. Those are very different situations, where one, we're talking about coordination of benefits with a known payer, and in the other, we're talking about, potentially investigating whether an exclusion applies or whether we have a clean claim that can be processed. So in the latter situation, you might be issuing a denial based on missing information rather than just a denial, which would be, resubmit whatever you have after the primary payer satisfies their responsibility. And of course, that should be, if the choice is to not pay for either reason up front, it should be a denial that's issued. I always tell clients in these situations to beware of the pend button. We've seen clients get into trouble where, I don't know if anyone has a literal pend button, but they'll say the claim is pended. And sometimes there's an attitude that you can pend a claim and just sort of put it into this ethereal dimension where it just
The
sort of is
purgatory.
frozen in time. Right.
Yep.
Yeah, the claim is just frozen in time for months and months and months. There are claim payment deadlines under the claim regulations, under the ACA, under ERISA. There's prompt payment deadlines under network contracts. If the choice is to not pay, a proper denial should be going out with an EOB referencing plan language and that sort of thing for sure.
I also want to talk about what other kind of coordination of benefits. In most of my day-to-day, I'm dealing with auto. If there's any kind of first-party benefit, so that would be PIP in some states, MedPay in other states. Sometimes there is a combination of PIP and MedPay available. Another example is workers' compensation. And a lot of times with workers' comp claims, work comp claim initially is likely going to be denied and then later possibly accepted. So it's just a disputed liability situation. So I like that you made that distinction earlier on. Specifically what we're talking about is when all things are known, whether payers are out there that are actually liable.
Yeah, and the mention of work comp coverage there is a great example of where you could see a distinction in those two situations I talked about, because most self-funded plans, especially if they use one of our templates, we have workers' compensation or work-related injury exclusions. So just the existence of work comp being out there as another payer, you could be coordinating with workers' compensation as another payer, or depending on your plan setup and your language, if workers' compensation accepts any liability, that indicates that the injury is work-related. You might be excluding it entirely. So there are two distinct questions of payability and exclusions versus coordination of benefits.
And coordination of benefits really comes down to, unfortunately, even if you're a self-funded ERISA plan, it really comes down to a lot of state-specific questions. And that's because those benefits, especially as far as when I'm talking about auto coverages, PIP, MedPay, first-party coverages, also sometimes known as no fault, those coverages are actually typically state-regulated benefits. And for example, here in Kentucky, where I live, PIP benefits are not just intended to pay the injured individual for their medical bills. They are intended to also cover some lost wages. If the person has to hire somebody to mow their yard because they're injured, it could cover those kind of costs. So that's another distinction within the coordination of benefits. If it's PIP, it may not only be required to pay medical expenses. In most states, there's a wide gamut. Michigan, up until 2020, had unlimited PIP benefits. So that was wonderful. If a plan had made any accident-related claims, we could pursue recovery from all of their PIP benefits, and those were unlimited amount of benefits. And contrast that to some states where they don't even have PIP or MedPay available. There are no benefits, or the member has elected to waive those benefits. And that really takes a lot of investigation and getting into the details of each state. Some states have what's called fee schedules. And so, for example, in Florida, the PIP carrier pays approximately 80% of all the accident related claims under their statute. So that means that there's just such a wide gamut of statutes, and having to coordinate those benefits, even if you're a self-funded ERISA plan, it can be kind of daunting. But that's why we're here to help with that. All right, let's talk about the different pros and cons of each of the Pend and Pay and the Pay and Chase model. As a reminder, the pen and pay is when the plan does not make any payments for accident-related claims until the PIP ledger or MedPay ledger or proof that there are no benefits out there, the first-party benefits available. If they do that, the pen and pay model, then they're really not, like you said earlier, Andrew, it's a matter of timing. Plan is not paying for claims that they should not be anyway. They are making sure that they are only paying at the proper time and essentially the proper amount. And that can be a great cost savings tool for a lot of our plans. Although there's a big cost savings in that they're not paying the claims until that they are for sure that they have to, they are the actual liable party in this situation. It can be costly to administer that kind of model because you have to have someone constantly updating and looking for that. It can cause member abrasion because you're looking for that information. You can run afoul of the prompt payment rules and the deadlines under the network agreements. And one thing I wanted to ask you about, Andrew, is specifically with the No Surprises Act and the balance billing of patients. Have you seen any of those ever happen when under the coordination of benefits provision?
For No Surprises Act claims, plans just like non-No Surprises Act claims, plans have payment deadlines to either pay or deny a claim. The NSA just provides another layer of that, another source of that obligation. But the NSA sort of takes the patient out of the equation, where the provider isn't able to go after them in the meantime. Of course, one downside with pen and pay here is that if your pen is actually a denial, which, as we said, at a certain point, it has to be, now the provider is able to go after the participant. If the claim is denied outright, there's no balance billing protection because it's not a balance bill, it's just a bill if the plan denied it, right? So you sort of take it out of the realm of the NSA by denying it and sort of open up the patient to, pursuit by the provider.
And that can lead to some member abrasion as well. We've seen that because the members don't necessarily understand the plan is coordinating the benefits, and that's allowable under the plan document. And the pay and chase model, that's when the plan pays the accident related claims as they come in. This one has definitely less administrative costs, and it does avoid any of the other concerns that we just talked about, the promptness of payment rules and network agreements. And then what we do is if the plan is a pay and chase model, we would then be seeking reimbursement after that payment has been made from any of the liable parties. What can be difficult with the pay and chase model is if the benefits have been exhausted to the member, like I was given an earlier example of the PIP benefits being exhausted directly to the member, maybe because for lost wages or something non-medically related, but yet there could potentially be all these outstanding medical bills. Then you have to sort all of that out, and ultimately there's just not any reimbursement made at that point. Okay, so I think we have a better understanding right now of the two different models. And Andrew, did you have any ideas on the pay and chase model as far as any additional pros and cons on the?
Yeah, I just want to underline even a little bit more the benefit of just getting your payment process quickly. Getting under the line with prompt payment deadlines under network contracts. We haven't discussed stop loss coverage yet, which is really important. If you have a claim near the end of the year and you penned it for 2 months because you're looking for accident questionnaires, that could be the difference between getting stop loss reimbursement and not getting stop loss reimbursement, which is huge. So, when it comes to ensuring that the plan never pays something that another party should have paid, right? The pen and pay is the better approach, But then in the end, after all the delay that can be associated, the amount that the plan ultimately has to pay could actually be higher if you're paying a billed charge instead of a network rate, or you're paying, without the protection of stop loss that you would have had if you paid it up front and then went after PIP or MedPay or work comp or whatever the other source was after the fact. So, they're both valid approaches. But in general, and I always say, we're not just saying this because we, make money on Subro. In general, we do recommend pay and chase as, the better model. But like I said, they're both valid approaches with pros and cons.
Andrew, actually, I'm glad you brought that up because we've been seeing more and more legislation proposed to limit the plan to seeking reimbursement to claims paid at the time of settlement. So, what I'm kind of doing is mixing a little bit of the third party subrogation reimbursement with that coordination of benefits, because that coordination of benefits can impact your subrogation and reimbursement out of any kind of additional coverages that are out there. And specifically in Florida, they passed recently a statute that prohibits a health plan from recovering bills which were paid after the date of settlement. A lot of times we don't know what the available third party liability limits are. And let's say you had a $100,000 claim. You didn't present that to your stop loss carrier because you knew that there was an auto accident. And we found out that the attorney held those coordination of any of the PIP benefits. And at the end, the plan then realizes that they are going to be responsible for those payments. And they hurry up and try to pay the claims as the claim is settling. Well, in Florida, if you're subject to state law, the plan is out of luck if those charges haven't been paid at the time of settlement. It can be very difficult for plans to come back and try to claw back that recovery. It's much on the subrogation side of it and reimbursement. What we do every day, it's a much smoother transition if we know what those claims have been paid, and then we can seek reimbursement from all of the appropriate parties. So I do appreciate you bringing that up, especially with the stop loss and those larger dollar claims.
Yeah, that's a good point. So I did have some notes here about kind of going over some of the models of coordination of benefits in general, but I think we're going a little long. So I think that might be something we have to save for another podcast.
All right. Well, thank you, Andrew. And thank you all for joining us for another episode of Empowering Plans with the FIA Group. Thank you.